This is about the role of dissent in rulings of the Supreme Court. Still thinking about the Supreme Court, I read another book, this one titled Dissent and the Supreme Court, Its Role in the Court's History and the Nation's Constitutional Debate. I thought it was a very solid book, but it was also long and difficult to read. It is a lengthy, closely reasoned analysis of very many closely reasoned arguments, fashioned by lawyers who can often be florid or clunky in their use of words. Many write like bandy roosters strutting about, crowing ceaselessly. Reading it was slow going, like a hike in treacherous Rocky Mountain terrain. Alexander Hamilton wrote, in one of his Federalist papers, that the judiciary was the least dangerous of the three branches of the American government. He thought that was so because the courts did not have access to either the purse or the sword. They did, however, have a club or a prod, and that was the law. They also had that high-toned name, fitting for a court of last resort, and they had their costumes, those robes, making them look like a priesthood as they gathered for their deliberations. And they operated almost in secret, handing down their opinions the way God gave Moses the tablets. Much later they would also have the forbidding ambiance of the marble temple. The court's public record consists of its majority opinion, which is binding, and its concurrences, when a judge agrees with that ruling in the main, but wishes to express some deviation particular to their thoughts on the matter, as well as dissent, the principal concern of the book, when a judge flatly disagrees with the majority opinion. And the ruling, though binding with the full force of law, is that, an opinion. Benjamin Cardozo wrote, "In a sense, it is true of any of them, that they may be decided either way. By that I mean that reasons plausible and fairly persuasive might be found for one conclusion or another." As I read through these majority opinions and dissents, I was reminded of poker players faced with the decision to either fold or call, a terrible, tough choice, especially when the stakes are high. Or a replay official in football who has the direct evidence clearly before him, yet, just as clearly, the call could go either way. It does come down to splitting hairs. The author was more interested in that ongoing constitutional dialogue than he was in any specific landmark decision. He showed time and again how an opinion could win a battle, but the dissent would win the war 30 or 50 years in the future. John Marshall Harlan, a Southerner and a former slave owner, wrote a dissent in 1880 that became the foundation for civil rights laws and Supreme Court decisions in the 1960s. The early court, led by John Marshall and Joseph Story, was interested in establishing itself, discovering essentially changeless general rules. Dissent then was infrequent. Later, dissent became a powerful and regular feature in the court's operation, as the judges sought to determine what best served the public interest in a country characterized by ceaseless change. On a TV show about jazz, the narrator said of bebop, it was the perfect mirror for the complicated world from which it sprang. That was true of the Supreme Court, as it considered matters such as free speech, warrantless search and seizure, interstate commerce, labor laws, due process, privacy, the death penalty, and affirmative action. As the times changed, so did rulings. There is an old adage, inter arma silent legis. In wartime, the law is silent. As with the legality of Japanese internment, influencing decisions on free speech, balancing the effects of clear and present danger with the open marketplace of ideas. Finally, I had further evidence of Oliver Wendell Holmes and his cherished policy of judicial restraint. He once wrote, "Of course I know, and every sensible man knows, that the Sherman Law is damned nonsense, but if my country wants to go to hell, I am here to help it." The judges seem to me to be like nurses, with the nation as their patient, constantly coming before them with various ills, irritations, and ailments. The judges have recourse to law and the Constitution in their efforts to effect a cure.